issue of information design is one that lies at the heart of changes that are occurring in the legal profession. We're moving from a model where all legal communications was on a one-to-one basis between lawyers and clients to one where we're more likely to be moving one-to-many, where we're likely to need to provide information to a large number of people who may not even be people that we're aware of at the time that we create that advice. It's an example of the old cliche about giving a person a fish and they can eat for a day, and teaching someone how to fish and they can catch their own fish and stink up the whole house with them. It's a situation where the costs and the rising costs of legal expertise mean that most people are going to need to be very, very certain that they need a lawyer before they will actually be able to commit the funds to seek that advice. People are already seeking advice for everything online, and often from very dubious sources, and there's going to be an increasing role for the legal profession in the provision of advice in a way that is as a more low-cost alternative. What does this mean about in terms of information design? Well, information design gives us a framework and some ideas as to how we go about creating this information in a way that serves clients. Design, the word design, is about a deliberate process of problem solving. So rather than presenting something in the way that everyone else has before, because, well, we just do what everyone else does, a design approach takes us along a path where we actually analyse what the client needs, who they are, what information they need, how they're going to access it, how they're going to use it, and gives us a stage-by-stage approach, particularly in the idea of human-centred design, that will help us understand what it is clients need before we go about starting that process of designing that information. And the kind of information that lawyers need to present are things like, well, what is the law? What can and can't you do under the law or under a new set of laws? What are your rights? What are the risks of a course of action? What are the likely legal outcomes of a particular course of action? What does this document mean? So there are all sorts of questions that already, as lawyers, we need to answer for clients, and we need to provide information to them. And the idea of information design is just that we become more disciplined in the way in which we do it. We actually learn more about the process rather than just going, well, I'll just go write something and hope that it's correct. It's a way of drawing on the work in other fields to inform what we do. We don't expect everyone to be an artist, although there's not a problem if you are. Of course, if you are a visually creative person, that will give you certain tools that you'll be able to use. But we don't. It's not a case of expecting you're all going to be able to design infographics, but you are going to need to be able to tell someone who can design information, who do have the other sets of skills, the way in which to present that information, whether it be in a slide or an image or a video or a website or just text. And while we don't expect you to be a visual artist, we do expect you to be a writer. One of the things we expect lawyers to be are strong writers. So you need to use that information design approach to understand when you write something that it's not just sitting there and letting it all flow out in whatever order. It's about that careful consideration of why you're doing this, what is the problem that you're seeking to solve, and how does your approach actually solve that problem. It is about thinking about an audience. Now, law already does much of this, and there is a certain bad reputation about conventional legal design in terms of legalese, in terms of bureaucratic forms and so on. So we already design legislation, we design forms, we design documents. We have a bad reputation for doing it in a way that serves our needs as lawyers rather than the end user's needs. And that's something that we need to be able to change. We need to be able to design forms and documents in a way that people want to be able to use them and find them to be useful. And the way in which you communicate is extremely important. The information designer Edward Tufte has written extensively around the evils of PowerPoint. And the one-size-fits-all approach of the PowerPoint slide. And he points out how the Challenger disaster was largely caused by PowerPoint, because the engineers who had the information they needed to communicate to management were forced to use PowerPoint to represent that information, even though that information wasn't suitable for being put on PowerPoint slides meant that the managers who had to make the decisions to save the people on the Challenger didn't have the right information. So a bureaucratic imperative to put everything on damn PowerPoint slides actually caused a major disaster. PowerPoint actually killed people. So this is an extreme example, of course, but Tufte brings home the point that forcing people to communicate in one way, or just adopting in a lazy way a form of communication because everyone else does it that way, can have extremely serious consequences. We need to take information seriously, and we need to deal with it in a way that's ethical. And this is where the legal professional ethics come in. There are already ethical standards around the way in which lawyers communicate. For instance, the Australian Solicitors Conduct Rules, 2011, Section 34 says a solicitor must not, in any action or communication associated with representing a client, make any statement which grossly exceeds the legitimate assertion of rights, or which misleads or intimidates the other person. It goes on to say in a later section that they must not always also use tactics that go beyond legitimate advocacy that are primarily designed to embarrass or frustrate another person. So, and there are similar provisions throughout the solicitors' rules and through the barristers' codes as well. These are focused primarily on the justice system itself and looking at the way in which the interaction and communication in the justice system has to be guided by ethical conduct. It's not just all about your client winning. You need to be ethical in the way in which you communicate. You have to be honest and forthright. Okay. I think those provisions and those ideas have a much, much broader impact when we consider the emerging role of lawyers as information professionals in broader society, and our responsibility to represent the law fairly, to describe the law fairly, and to not use that process to distort people's impressions of the law. So, I mean, what are things that obviously lying is wrong, and lying is something that's a breach of the codes of conduct. But there are all sorts of other things that can be done in the course of use of information that fall short of absolute lying, but are things that we need to think about ethically. So, so-called white lies of omission, where you allow someone to consider something because you haven't given them all the information. Now, the solicitors' rules say if someone gets the wrong end of the stick, you're not required to correct them. But if you allow someone to believe something because you haven't presented them with an important piece of information, that's just as bad as lying. Overstating the value and credibility of information is something else. And we look at data, you could have a very small sample that your research is based on and then pretend that this is somehow representative of society at large. And people do this all the time. They survey, say, 50 people, and then they say this represents a broader social trend, whereas 50 people is not significant in any kind of statistical sense. So we have to be aware of this kind of ethical misconduct that occurs in research that might underpin the things that we communicate as lawyers. There's also the situation where you might obscure information in a confusing presentation. This is something law is notorious for in the past, in filling everything up with legalese so that no one can understand what you have to say, and therefore confusing and humiliating, embarrassing, or whatever as the rules say, but providing an environment in which people aren't aware of the correct information because you've bamboozled them with legal doublespeak. And there's also the sense in which hitting emotional chords in communication can be done in a way that's manipulative to the point of dishonesty, where you can raise allegations or raise concerns in a way that engage people in an irrationally emotional way, that alarm them and disturb them, and that can be used to distort the message and distort the truth of the data that you're communicating. So there's a lot of things to consider going into the design of information from an ethical perspective, just in terms of information design, but also in a legal ethical context as well. And going forward, this is something that's going to be very important as we have more and more law websites and interactive law tools and law mobile tools. It's going to be very important that people are on top of all these issues so they don't get themselves into ethical hot water. And that's where the future is going to be. We still is going to be a role for bespoke legal advice in a small number of circumstances, in very, very serious circumstances, where that cost can be justified. But a lot more legal work will be done on creating advice or information or tools that can service a broader range of interests. In the notes below, I'll refer you to the Information is Beautiful site, David McCandless's site. He's a key leading information designer, and he does some quite nice things with information design. Not that we're going to expect you to do those sorts of things, but there's a great piece in there that's called Based on a True Story, that looks at Hollywood and Hollywood's supposed use of true stories. But it's an interactive design. You can actually manipulate it from the web window. You can move things around and watch how that changes the data. That's the sort of thing that's going to be an emerging practice in law. That's going to be important. Providing the right interface that someone can pick up, say, off their phone and very rapidly find out answers to legal problems. Of course, how we turn this into income for the profession is a completely different issue, because people have gotten very used to things online being free. So that one of the challenges in this emerging change in the profession is, well, how is this all going to get paid for? And I'm sure there's going to be solutions. I'm sure there are very many clever people studying law and are existing lawyers. Maybe one of you are going to be the ones who come up with the solution. They're going to come up with the PayPal or the Patreon or the eBay of the future for the law. But returning to the main point, whatever that future is, information design has a strong, prominent part of that future.